at the time when she, when you were conceived, when they did the deed. Now, Africa, there's a fatwa. Right now, the fatwa says if the child was born 6 months or more after the nikah, after the marriage, then there is a presumption that the child was conceived in wedlock. So 6 months or more after the nikah. So if they come to with the Islamic will, they come to the Muslim Judicial Council and say, look here, right, there is a person, he passed away, he had a wife and he had 3 children. They don't ask any questions. They will ask, where is a marriage certificate? There is a marriage certificate. There's evidence they were married this date. Now they ask, where are the birth certificates? Where are the identity documents of these 3 children? They will look at the eldest child. If the child was born 6 months or more after the nikah, they will say, look here, right, this child is entitled to inherit. If the child is born less than 6 months, right, 5 months or 4 months, they will state that the child is not entitled to inherit. Right, so in this African context, what happens is, in order to educate the Muslim community, then they advise that you then may make use of the wasiyah clause. Right, so you say that I hereby make a wasiyah, a bequest, in favor of my child conceived out of wedlock. Even do it, I bequeath to my child conceived out of wedlock the same share that my son conceived in wedlock would inherit from the Muslim Judicial Council certificate, on condition that that share does not exceed 1/3 of the net estate after all liabilities have been deducted. So you as you know, the wasiyah cannot be more than 1/3. And if that amount is more than 1/3 that the other son inherits, then it must be reduced to the maximum of 1/3. Right, so these are a few examples of how, within the South African legal context, the Islamic law of succession finds application. Right. Now, the next question I want to look at is what happens. Right? In Indonesia, we find that if you pass away without a will, without a wasiyah, what happens to your estate? There's certain consequences, right? It must go somewhere, right? Either the Quran or Sharia, in civil law, whatever, it must go somewhere. It doesn't just stay right in the air. Now, in South Africa, the Islamic law of inheritance has not been codified. There's no act of parliament that says what should happen to your estate once you pass away if you are a Muslim and that Sharia law finds application. In Indonesia, we're speaking about, was a person Muslim, was a person not Muslim, where's the evidence, all of those things. In South Africa, we don't have that. If you pass away without a will, automatically there is an act of parliament. You can download the act. It's the Intestate Succession Act 81 of 1987. Right? The Intestate Succession Act 81 of 1987. It's a very short act. If you download it, it's about 3 pages. Now that act in South Africa, it basically says, if you pass away without a will, without a wasiyah or anything, then automatically this find application. Now, that which finds that is different to the Quran. It's different. If a person with two and a son and a daughter, right? So the mother inherits something, the father inherits something, the wife, the widow inherits something, and the son and the daughter inherit something in terms of Islamic law, as we've discussed earlier on. In terms of South African law, and in terms of that specific act, it says that the surviving spouse should inherit a minimum, okay, but it's not dollars, it's in rands, but it says a minimum of 250,000 rand. Right, that's a minimum she must inherit. Or a child's share. Right, so how does it apply in South Africa? I'm married to my wife in terms of Islamic law. I have my mother and father is alive. I have a wife. I have 4 daughters. Let's say my wife got a son, so I got sons and daughters. Now, as per Quranic injunction, 1/6 for the mother, 1/6 for the father, 1/8 for the wife, and the rest to my son and daughters. Sharia compliant. That is only if I have a last will and testament stating who my beneficiaries are. If I pass away without a will, the Intestation Act 81 of 1987 finds application. And that act basically says that my wife, I'll speak in rands now, 200,000 rand, everything goes to her. Nothing goes to my mother, nothing goes to my father, nothing goes to everything goes to my wife, nothing goes to my children. However, if the estate is big, let's say it's R1 million, right? Or let's say it's 2 million rand. Then we take the surviving spouse, the wife, and we take now the 5 children. That's now 6. We take the 2 million, we divide it by 6, we get a number. That number is definitely more than 250,000 rand. So in that instance, the wife will inherit that amount, 2 million divided by 6, she will inherit, and the children will inherit equal shares, male and females, the rest of it. My mother and my father will inherit nothing. As you can see, there is a big discrepancy between Islamic law and South African law. All right. Coming back to the estate. Initially, before the case of Daniels versus Campbell, our marriages were not recognized. Okay, no, sorry, quick. The case of Daniels versus Campbell, our marriages were not recognized. So in this case, they again used the South African Constitution. Right? In terms of the South African Constitution, what happened was, this guy, he was married to his wife. Right? And whatever happened, he then died. When he died, his wife was not entitled to anything. And the reason why his wife was not entitled to anything was because the marriage was not recognized. Now, in the case of Daniels versus Campbell, we can download it as well. What happened was, this lady then argued in court that, look here, you're giving me nothing. You're not recognizing my marriage. And this government, South African government, we say we're a constitutional democracy, we say we've got such a lovely constitution on paper. You haven't given us, in over 10 years, you haven't given us any legislation that governs Muslim marriages. And now my husband passes away, I'm entitled to nothing. Right? She, in this case, then went to the High Court and said, look here, this government, right? And the law of this government, that is unconstitutional, right? It discriminates against me. It's discriminating against me based on my marriage. It doesn't recognize my marriage. I'm not equal to another lady who's married in terms of civil law by the Department of Home Affairs. I don't feel that I am an equal citizen in this country. Right? This type of argument was made. And the court then said, all right, that is the case. We agree with you. This government should have had enacted legislation that recognizes your marriage. And as a consequence thereto, we are now, remember early on, I referred to a constitutional supremacy. The courts were then saying, look here, we have the power. So deemed to be a spouse in terms of that piece of legislation. It seems to be a win for the South African Muslims, right? But I've now just explained to you, by way of examples, that the rights that that widow is entitled to is not what Allah stated in the Quran in verse number 12. But then again, we look at this lady, this poor lady is entitled to nothing, right? To nothing at all. And the family also give her nothing because they don't want to give her anything, right? So she had to do something. So she was forced to go to the courts and at least go claim something. And that is how the South African Constitution was used in order to benefit South African Muslims that were married in terms of Islamic law in a mosque in the event where their marriage was not registered in any official capacity by the government. The last case I'm going to look at is the case of